Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is present with channel favorite, Zach Morgan. How's it going?
I'm good, Aaron, and I wanted to make sure that everybody knew Mini Mike was joining us today. He's going to stand in Big Mike's stead, so he'll be with us today as well.
Very cool. You know, we got to get you, Mini Mike, a Xenu costume. So, Xenu, Marilyn Honig is the one who makes these in like her, I want to say Etsy shop, and she also makes another one called the Duke of Chug. Have you ever heard of the Duke of Chug?
In passing.
So he's the guy that L. Ron Hubbard based on. He's the other like intergalactic
okay, that's how
figure that L. Ron Hubbard based all Scientology computerization policies on. I think the Duke of Chug had like mastered computerization, and so Scientology, L. Ron Hubbard enacted policies to mirror the Duke of Chug's policies, and that's why Scientology still sends telexes. Oh, they don't literally send telexes. Okay, so but that's not what we're here to discuss. We're here to discuss David Miscavige and his involvement in the labor trafficking lawsuit that was filed against a handful of Scientology organizations and against him personally. And that is key to this conversation here. You know, real quick, I don't want to assume that our viewers already know exactly what we're talking about. So last year, a civil lawsuit was filed against about 5 Scientology organizations and David Miscavige by 3 former Scientologists, former Sea Org members. And one of the major hurdles that case had to clear was whether the internal arbitration agreements that all Scientologists sign were going to be enforced in this case, or whether they were going to be thrown out due to the fact that they're signed under duress. Unfortunately, the court has ruled yet again that even in order to determine whether these contracts were signed under duress, they actually have to go to arbitration so that the arbitration panel can decide whether the arbitration agreements were signed under duress. Like, it's mind-boggling to a layperson that this could be happening this way. And yet, at the same time, I think there's an argument to be made. Someone else made it to me, although I'm not sure I totally understood what they were saying at the time. But I think you're also making the argument that that ruling may not actually apply to David Miscavige himself. Can you help me understand what's going on here?
Sure. So, and we see this most often in like government officials. You know, a mayor is sued in their personal capacity versus in their, you know, capacity as mayor of, you know, the town of Whoville or whatever. I can sue somebody 2 different ways. I can sue them professionally in their capacity of the leader of RTC or as the president of Aaron Smith-Levin Incorporated or whatever. And that means I'm suing them in their business capacity based on decisions they made in furtherance of their business or official capacity. And the reason we do that, so instead of suing 10,000 employees of a 10,000 employee company, I sue the chairman of the board who represents the business and acts on behalf of the business. If that individual has also committed a personal wrong against me, I can also sue that individual, not in their capacity as a business leader, but in their capacity as an individual person. And the arbitration agreement, having never read it, but understanding how arbitration agreements tend to work, the arbitration agreement probably says, you know, if you're not allowed to sue, you have to go to arbitration for any grievances that you believe were committed by the church or by anybody acting on behalf of the church. However, if David Miscavige acted in any capacity beyond his authority as the church, or in a manner that would expose the church to excess liability, I can sue him personally. Yes, he, you know, did these bad things or whatever in furtherance of the business of the religious organization, but he also committed these acts in an individual capacity. So it's a little bit tricky to understand, but a classic example would be if you're driving a corporately owned vehicle drunk and you hit me, I can sue the business for negligently entrusting you to drive the business owned vehicle and you personally for hitting me while drunk.
Interesting. Now, in the lawsuit, David Miscavige is personally named as David Miscavige, not chairman of the board, RTC. How do we know for sure how are we able to determine whether Miscavige is being sued as an individual or as a corporate officer?
So most commonly, so the easiest way, so different states call it different things. Colorado calls it the caption. Oklahoma calls it the style, but the block at the top where it says A versus B in the, district court or circuit court or superior court of, it will say things like David Miscavige in his capacity, in his official capacity, religious capacity, comma, and individually. So I could say it on the face, or the pleading or the complaint has to enumerate step by step, here's the things that I'm alleging were done to me that were wrong. And in those explicit, I can specifically say David Miscavige individually, Joe Blow individually, Jane Doe individually, regardless of, so I can make a pleading on its face as to an individual person or an individual act, as well as the greater act of the religious organization as directed by the leader of the organization.
Interesting. I'm trying to pull up the actual thing, the actual issue itself, so I can see exactly how it's written. But in my previous attempts to do this, even though I know I have it saved somewhere here on my computer, my previous attempts to pull this up just on the internet, it usually takes me quite a while to get to the actual thing. Here we go. Gawain Baxter, Laura Baxter, and Valeska Paris versus David Miscavige. It just says David Miscavige. It doesn't say anything.
But then does it later in the pleading, does it say further down on the defendants, it lists a variety of Scientology enterprises, right?
Oh, well, here, let me actually, let me share this to the stream.
Throw it up there. Let me look at it.
I'm trying to be very careful to share the one specific tab, so just give me a sec. Oh, there it is. Can you see it?
Yeah. So versus, David Miscavige semicolon. So that David Miscavige semicolon, that semicolon has the legal effect of isolating the prior person, in this case, in his individual capacity. Then CSI Inc., RTC Inc., IAS Administrators Inc., COS Flag Service Org Inc., and COS Flagship Service Org Inc. So each of those religious entities is being sued as in a corporate capacity. But the way I read the face of that pleading, David Miscavige is being sued personally.
Very interesting.
He may also be being sued by virtue of his role within the organization, but because it doesn't say DM as COB of RTC or whatever, because it just says his name, he's being sued. The way I would read it, and most judges that I've ever met would read it, it just says that name. That person is a defendant in the lawsuit.
Right. Now, there's another reason why the ruling that came down doesn't actually yet at least apply to David Miscavige, and that's that he was actively preventing himself from being ruled a party to the case while these entire arguments and pleadings were playing out. And he wasn't actually added to the case until just a couple weeks before the decision regarding the enforceability of the arbitration clause came down. But that decision was coming down based on arguments that were made before he was even a party to the case. Right. I have been told by people with firsthand knowledge of the proceedings that an entire new set of arguments is going to have to be made for why those arbitration agreements should apply to David Miscavige himself, simply by virtue of the fact that he wasn't a party of the case until too late. But you're saying, no, that's not actually the reason the ruling doesn't apply to him. It applies to him because he's being sued as an individual. But couldn't someone argue that the arbitration agreements apply to all Scientologists, that the arbitration agreements say you promise not to sue any individual Scientologist?
I would have to see the language of the arbitration agreement. And ultimately, when these motions are filed and these responses, the arbitration agreement will have to be attached as an exhibit, because the judge is going to have to interpret the language of the arbitration agreement. An arbitration agreement is simply a contract. And so the language of a contract is open for interpretation. And that's in contract disputes. That's exactly what the court is doing, is interpreting the contract and its legal enforceability.
Interesting.
And so, that's we can call it what we want to, but ultimately an arbitration agreement is a contract.
So let me ask you a question right there.
Sure.
So right off, just immediately, one could say, well, it's a contract between the individual, and it has to be a legal entity, right? And the Church of Scientology, I guess. Some organization. I mean, it can't be it has to be a contract with either a person or an organization, right?
Exactly. You can't contract with yourself, and you can't contract in what we call the abstract.
Right.
Right.
Right,
I can't,
right.
I contract with the world to do the following. No, there has to be some sort of mechanism of enforceability. And the mechanism of enforceability is are the parties to the contract.
So to the best of your understanding, is the Church of Scientology legally allowed to enter into a contract with an individual, and where that individual is promising the Church of Scientology not to ever sue any other individual who calls themselves a Scientologist? Or does that mean, no, you can't do that because you're not a party to the contract?
Yeah. So they can contract with the religious entity, but not with all followers of the religious entity. That's sort of like saying back like in the Spotlight days with the SA scandals in the Catholic Church in Boston, they had settled with a bunch of the defendants. But that doesn't mean that every other victim of priestly abuse is bound by that same settlement. It's only between those parties and that legal entity.
Interesting. So if Miscavige was being sued as the head of RTC, then the contract that these former Sea Org members signed with the organization would, as chairman of the board of RTC, that's included.
Correct.
But David Miscavige, the individual, are you saying he isn't, or he might not be?
He might not be. I haven't read the arbitration agreement in its entirety, and I also don't know what the federal courts in the state of Florida are doing as far as what the federal courts in Florida in that circuit are doing as far as the way they interpret contracts, because ultimately the district court judges are going to be bound, and the magistrates are going to be bound by the appellate court decisions as it pertains to interpreting contracts.
Right. That's interesting. I mean, I might not be able to quote them or cite them or pull them up right now, but I know that the rulings that have come down on the enforceability of these arbitration agreements have not delved into the issue of whether individuals operating outside of their capacity of staff members would be included in the umbrella of enforceability, because in all the previous suits, it is Scientology organizations themselves that have been sued.
Yeah. Yeah. So, people tend to get lost in the various hierarchical structure of the overall organization that is the church. But ultimately, it's just a legal business. And if you're acting within the course and scope of your legal business, or in a unreasonable manner, or if you exceed the authority of your position, then you've opened yourself up to possible civil liability. And the legal term for that would be piercing the corporate veil. I mean, as somebody who's, been involved in Wall Street, you're familiar, the duties to shareholders and things. And the reason we have to track everything that we do in that community is to protect the corporate entity. And it's the same sort of thing. If no reasonable person would traffic humans under their authority as the leader of a business, that's no different. It happens to be a tax sheltered business, a tax-free business, but it's still a business.
Right.
And so if he's acting outside the course and scope of his authority, then he's certainly subject to personal liability from a civil perspective.
That's amazing. Before we wrap up, can I ask you a very specific question about the proceedings in the Danny Masterson case?
Of course.
Right now?
Yeah, I've been following all your stuff on that, so I should be up to speed.
So just this morning, Philip Cohen he submitted a subpoena for copies of all communications, text messages, emails, otherwise, between the latest victim, latest. It's actually one of the earliest victims, but
sure.
who will be testifying as a witness for the first time. Any and all communications that she's had with anyone regarding the attack by Danny Masterson back in the year 2000. Judge Almeida commented on this and said, the information you're requesting is pertinent to the defense in this case. However, your request is overly broad, and granting your request would result in a trial delay. Therefore, I'm throwing it out.
Yep.
What prevents him from submitting the exact same request tomorrow with a bit more of a narrow scope? And I was troubled, just as a layperson, my curiosity was, she's already acknowledged the information is helpful to the defense. How can you say, but I'm not going to grant it because it would result in a delay of the trial. But the trial is Danny's supposed to have an opportunity to have a proper defense. Did she paint herself into a corner a little bit?
Not necessarily. So part of that's judicial discretion. You can't claim that you want a speedy trial on the one hand and then try to find repeated ways to delay the case. She's also, as you've argued, well aware of the ability at this point to manipulate your way onto a jury. Very well aware of that. The court has calendars that it has to keep because there's other cases on that judge's docket that she, has to tend to. But also, just because something is relevant doesn't mean and otherwise discoverable doesn't mean that the collection of that evidence wouldn't be overly burdensome.
I see.
And so given the time now, if he comes back tomorrow with a subpoena that's very narrow, I want all the text messages between Jane Doe and Bob Smith from April 1st to September 1st, 2007. Perfectly reasonable request. That is extremely narrow, tailored to solicit specific information. But if I want every person she's ever talked to ever in writing about this thing, that's overly broad, because the prosecution would have to gather that information. They'd have to look and see, was some of it made in confidence to a therapist, or was it made in confidence to a personal attorney? It would take weeks of screening and redacting and reviewing this material, but he could certainly tailor something much more narrow. He might have better luck. He might not. At the end of the day, making last minute discovery requests are probably going to get overruled, because even though her rulings on this are fairly recent, he's had 3 or 4 or 5 years to gather this information and just simply failed to do so. And now on the eve of trial, you're using this as even if he's not using it as a delay tactic, it's functioning as one. And the judge says, nope, you've had plenty of opportunity to gather this information. The fact that you finally decide you need it isn't my problem.
Right. That's interesting. Also, I forgot that a right to a speedy trial is just as important of a right as any of the other rights.
Mm-hmm.
So the delay, that's interesting.
The right to a speedy trial is just as important as a defendant's right to have the merits of their case adjudicated after charges are filed.
Very interesting. And also, even if the judge were to grant that subpoena, it's not like Kathleen is scheduled to testify in the next week. Could she grant the subpoena and it doesn't even result in a trial delay, because they can be doing this behind the scenes while the rest of the trial is going on?
Oh, theoretically, discovery is ongoing, and there's a duty to supplement. So if at any point along the way the defense discovers new evidence, or the prosecution, even if it's a day before closing argument or a day before somebody's supposed to rest their case, if new evidence is discovered that they seek to use, they have to disclose it. That doesn't mean it gets in, but both sides have equal opportunity to review the evidence that's being proffered.
Awesome. Well, that's why I love having you on. You have the best answers. Okay, let's see. Here's a super chat. H4M Street Team. Do you think you guys going to the trial should wear a teal ribbon? Support of SA awareness is teal, so Jane Doe knows who are the good guys. Well, I'm not. That's generally not my thing to do, like visual aids. Go ahead.
So I actually had this come up in a case. I represented the parents of an infant who died as a result of medical negligence by the care team upon birth. And they had, T-shirts that had the name and the birth date, and they had, the ribbons and stuff. And the defense moved, we don't want any of this in the courtroom, either by the witnesses, including the parents, or family and friends, because the jury is going to see that, and it could unduly affect the jury. I had a duty to my client to argue against that. Hey, let them wear it. I lost. I should have lost. I recognize when I should lose certain things. I lost, and I should have, because I recognize that would unduly influence it. And I wouldn't be surprised if somebody were to show up in support of either side. If one of the attorneys saw it, brought it to the judge's attention, the judge may very well say, either go change your clothes or cover up that particular campaign ribbon.
Yeah, that makes sense. All right. Well, I think we kept it pretty short and sweet and to the point. And hey, one of these days, as soon as you get your YouTube project ready to go, I'm going to promote the hell out of it whenever you come on here.
I appreciate that. We'll see you guys soon.
All right, guys. Talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. subscribed or not, subscribe